And we stand ready to hear the second case, Samuel Willson versus the Louisa County Board of Supervisors. Good morning. This case is 25-0405. For the Appellant Board of Supervisors, we have Holly Corkery. And for the appellees, we have Jennifer Zahradnik. Ms. Corkery, whenever you're ready.
May it please the court. Good morning. My name is Holly Corkery. I represent the appellants, Louisa County Board of Supervisors, Brad Quigley, Randy Griffin, and Chris Ball. Respectfully, the district court's order in this matter erred on several points. Specifically, there's legal error on the writ of certiorari claim and the open meetings decisions. I'm going to start with argument related to the writ of certiorari claim this morning. The factual timeline of events is important here for the court to understand. On June 3rd, 2022, a local news station made a Facebook post about the potential sale of Baird Timber. Baird Timber is a piece of land in Louisa County, and it's managed by the Louisa County Conservation Board. On June 6th, the Louisa County Conservation Board unanimously voted to retain and not sell Baird Timber. Mr. Willson, the appellee, was on the Conservation Board at the time and part of this vote. On June 7th, in response to a question about the Louisa County Conservation Board asking, isn't a conservation board supposed to conserve, Mr. Willson responded, they are, but when the board is corrupted, it runs astray. Following complaints about this statement, Paul Groof, the county's HR contractor, did an investigation, including interviewing Mr. Willson. On June 21st, 2022, the Board of Supervisors, the body that appoints and removes the Conservation Board pursuant to Iowa law, voted to remove Mr. Willson for making false allegations that constitute malfeasance. Mr. Willson received a letter confirming his removal. He appealed his removal, and it was heard at 2 Board of Supervisors meetings. Then following on August 25th and September 6, 2022, and ultimately his removal was upheld. During those meetings, Mr. Willson had the opportunity to present arguments from counsel. The Board of Supervisors heard from members of the community. They heard from their own attorney or their own county attorney, and they heard from the county's HR contractor, Mr. Groof, who shared concerns that individuals felt defamed and slandered by Mr. Wilson's statement.
Writ of cert really comes down to the meaning of malfeasance, or whether the conduct fit into what could be described as malfeasance. Is that right?
The writ of cert comes down to whether or not the Board of Supervisors acted illegally. And the meaning of malfeasance comes into that, but they acted illegally if they did not rely on substantial evidence, or if they acted in an arbitrary, capricious, or unreasonable manner. So
District Court's decision ultimately was there's not malfeasance here. You know, what happened doesn't reach, you know, the relatively high standard of something that's wrongdoing by a public official. So, I mean, what's your strongest case of it being malfeasance?
my strongest case law? No. My strongest argument? Well,
Comments on Facebook, you know, not mentioning that he was a board member at all was malfeasance in office.
really dig into the district court's order, the district court relied on, there were 2 reasons essentially why they found malfeasance, or that there was an illegality. The difference between the word corruption and corrupted, which they said was a misstatement by the Board of Supervisors between that noun and adjective. And then, as I went on about the facts at the beginning, a factual issue where they found that Mr. Willson actually made the Facebook comment before the vote, which is not the facts and not what the record states. So those 2 errors cause problem, but to answer your question, my argument as to what malfeasance would be here, we have members of this board, of the Conservation Board, who are calling to complain, as the record reflects. One of them testified at trial. They're upset, they feel slandered, they want to quit. They don't want to be on this board with someone who's accusing them of being corrupted, and it made a hostile environment. It made it uncomfortable for them to be there. So with that, information and doing an investigation, the Board of Supervisors made the decision that this constituted malfeasance at that point.
Argument about hostile environment that was, I think, in the letter, removal letter maybe, did that kind of come too late in the process to communicate it to Mr. Willson?
There's argument about that, but I think that gets into an argument that was never pled in the petition, which is due process, right? So if Mr. Willson wanted to make a due process argument, he could have made that when he filed his petition, but he didn't. He filed a writ of cert that said he was removed illegally, and then he filed the open meetings claim separate of that.
But when we're looking at sort of the core of was it malfeasance, do we really look at the others' reactions or what we think would have happened within the Conservation Board, or are we limited to looking at the Facebook post?
I think you look in the totality. I mean, the case law tells us, the Iowa case law, which is admittedly limited, tells us that malfeasance is what one ought not do. So making, whether he knew it was just outright false or whether he made it recklessly, but making a statement that a group of people are corrupted with nothing to base that on, that is something one ought not do, especially on Facebook when you know it's a public post. And then you see the reactions to the post and you do nothing to go in and correct anyone's understanding, which is what the record reflects happened here.
Can you talk about, so one of your other arguments is that even assuming, that the court was correct that this was malfeasance, that the court couldn't extend the terms in office. Can you walk through just factually, when did Mr. Willson come into office? When did his term end?
Mr. Willson came into office January 1, 2020. His term then should have ended December 31st, 2024. It's a 5-year term statutorily. And the rules of civil procedures regarding writs of cert tell us that you can't substitute a different or amended order for the one being removed. So the district court, even if this court disagrees with everything I've said up to this point, even if he was going to be removed, or even if he needed to be reinstated, he could only be reinstated to a term of office that was set by statute. The district court couldn't do anything more than reinstate him and essentially sustain the writ.
So if that term is over, why is the case not entirely moot, at least as opposed to his removal? Like, isn't anything we do here just giving guidance then?
Well, he is I mean, this is outside the record, but the county is following the district court order because we have a court order telling us to put him back in office till, I think it's July of 2027. So, no, I don't believe.
If a case is moot, that order would get vacated, and that would no longer be in effect. But I mean, there's quite a bit of case law out there that when there's a removal from office fight and the term is over, the case becomes moot afterwards. So there's exceptions to that, public importance and those sorts of things. I mean, do you have a position as to whether or not we should go down one of those paths and still decide the merits if we were to think it was moot?
It would be helpful guidance for these counties to understand what malfeasance is. We cited to a case that's 100 years old about what one ought not do, so I do think that would be helpful in these situations. But I agree that finding that the remedy was inappropriate, which we argue that it is here, would lead to the case essentially being moot because his term has already ended. It ended before the court entered its order.
What remedy would be available here? Say we agree with the district court on the merits of that question. What would the remedy be?
The remedy would have been that he could have been reinstated to his term of office.
But if that's passed already, then he's left without a remedy?
10 days passed when the district court entered its order. The district court could have entered its order, following the case that went to trial in September. And it didn't, so that could have been a potential remedy. Also, Mr. Willson had the opportunity to ask for injunctive relief pending this entire case, and he did not do that. With my last minute, I'm just going to turn to the open meetings claim briefly. We have 2 reasons that we believe that the Chapter 21 claim should be overturned. The first is that the district court relied on improper evidence. The district court was the fact finder here and relied on implications by an attorney made in a cross-examination statement The order says that. We don't have to guess what the district court was doing. They very clearly state that. Even with those implications also, the district court then found that the county violated Chapter 21. The county went in under imminent litigation. At the time, County Attorney Parsons competently testified that he believed the county was going to be sued. He stated in the minutes, which is part of the record, that he believed there was a viable open or First Amendment claim here for Mr. Willson that he was concerned about. He advised his client to go into closed session based on this. Plus, you had information from Mr. Groof that members of the community and the Conservation Board were upset about defamation.
Happened before the removal, is that correct?
Yes.
Is there anything in the record when the council is talking about this being a potential First Amendment claim, whether that the thought was that that's like a standalone First Amendment claim for what had already happened, or whether that was you'd be facing a First Amendment claim if you take some more action? Is that clear from the record?
My recollection of the minutes is that you would be facing a First Amendment claim.
Thank you, Counsel, and you'll have more time on rebuttal.
May it please the court, counsel. I think this case really involves a government body that chose secrecy over statute and retaliation over reason. When you look at the transcript of this case, there's a lot of focus in the questioning by Ms. Corkery in regards to, did Mr. Willson ever apologize for the comments? You know, did he ever show any remorse for the comments that he made? This wasn't a case where, you know, he made comments that were singled out. They didn't say, this person did this person did this. This was a comment that said, when the board when the board is corrupted, it runs astray. And there was a lot of focus by the district court in regards to, you know, what the strict meaning of the word corrupted is, you know. And I think part of what has brought this case to the court is the way that we interpret sentences, the way we interpret language, and the way we read things. You know, when you look at what, a board is a group of people, and it's not normal to say a board is corrupted. It's more normal to say a board is corrupt, which is a negative connotation, which can be read as offensive. And usually when you read those types of things, if it doesn't feel normal as part of the English language, you drop off the ED. It would be no different than if you were reading a sentence that said, in the spring, you naturally would eliminate that second the when you're reading it or reading it aloud, because that's just the way our brains are all trained to do.
Have been malfeasance if it had been more explicit, like, yes, I believe the Conservation Board is corrupt, or the members are corrupt?
I don't believe so, Your Honor. I believe malfeasance is something that prevents you from doing your job. If anytime somebody made a comment, whether it be in public, whether it be on Facebook, expressing some type of opinion in regards to a board or a commission or a tribunal, I mean, that right there is our definition of First Amendment protected speech.
In the board meeting, and maybe repeatedly in the board meeting, was consistently kind of, accusing the board members of being corrupt. Does that rise to the level of malfeasance?
I don't believe it prevents that person from doing their job while in office. I think with the legislature and their approach to requiring us to have gender balance, to have political balance on boards, to try and get all different perspectives, I think there's always going to be a level of discourse between one side of the fence or the other. And I think we've always been very free to be able to express that discourse. And I don't think, if it was excessive, and when I say excessive, you are argumentative about everything. If you cannot have a civil conversation with a person and it's repetitive over multiple meetings, multiple months, those types of things, then yes, I think that would affect his ability to do his job in this situation. But
I just want to ask you about the definition of malfeasance that you're using. Do you think it requires something more than an act which a person ought not to do at all? Or do you think that's the definition that we're working from?
so I think the Definition from that 1910 case that we had cited, that, you know, that everybody talks about, that you ought not do it. I think that is in regards to, I would say, the general public. But when you you know, if it's something you shouldn't do, you know, is it illegal or is it not? And if you're on a board, does it affect your ability to do your job and that you've been, you know, appointed to do in that case?
From?
When I looked at the Kirby versus Henderson case from 1910, you know, that was a case where they talked about the mayor being removed from office because he was intoxicated while on the job. And the court found that his intoxication prevented him from being able to do his job, and that constituted the malfeasance. And so when I look at that, you know, I see that to say, yes, that's something he ought not do. A normal person should not drink on the job, but in addition, it affected his ability to do his job as the mayor and oversee the duties of the mayor while he was during those working hours.
The Board of Supervisors could remove a board member for malfeasance, you know, if the board member was convicted of theft, totally unrelated to the job, but stole or burglary. Would that be malfeasance that could remove a board member?
I think that could go towards, you know, theft is an act of dishonesty. If those persons were in charge of public funds, I think the supervisors could definitely find that there would be a case of malfeasance there.
That it would have to be during your job duties, but somehow affecting your job duties.
Duties, you know, to warrant removal.
Can you talk about the remedy issue? I mean, I'm really troubled. The statute sets up a 5-year term, staggered 5-year terms, you know, and goes to the trouble of, you know, setting that all out. So there's going to be a board vacancy every year. How does the court have the power to keep someone in term longer than the 5 years?
Unfortunately, you know, everything takes time to work through the court system. The way I've looked at this case, you know, not having been an original trial counsel, you know, Mr. Willson doesn't receive compensation, so there's no monetary availability to him in regards to these proceedings. It's an equitable remedy to reinstate him to office, to allow him to continue to do the work that he was doing. When I looked at this, I looked at it from the standpoint, I've represented quite a few cities, you know, over the years, and we have people that retire, we have people that step down, we have people that pass away while they're in office. The board will appoint somebody to serve out the remainder of the term. I think in this case, what the district court did was say, this wasn't fair that you were removed. We're going to allow you to finish your term, and when you get to the end of your term, the Board of Supervisors can appoint somebody to fill that additional, you know, time frame of the 3 years or whatever that's left, that would bring that back into that staggered position. I don't think it's inconsistent with what happens in a normal basis with boards and those types of things. And if we allow the supervisors to remove people and then not give them a remedy, I think we're going to struggle to get people to volunteer to be on boards, to serve for 5-year terms. I mean, those are long terms. I mean, most city councils and those types of things are 4-year terms. A 5-year term is a substantial appointment. We always struggle to find people to serve on those, and I think by saying that the issue is moot and that he should not have been reinstated, I think punishes him and really discourages other people from giving public service.
About your open rec, oh, go ahead. Can you talk about the open records claim as well?
In regards to the open meetings, that's okay. In regards to the open meetings, number one, I think they cited the wrong session when they originally went into or attempted to go into closed session. To me, it should have been under subsection I, where it talked about the professional competency and the removal of a person if that person had requested it. I think that would have been a more appropriate section for the supervisors to consider rather than imminent litigation. In this case, I don't believe there was any imminent litigation pending, because if the Board of Supervisors had come out of the meeting and said, you're good to go, we would not be here.
Court's reliance on the unsworn statements of the attorney If we were to agree that those were improper to rely on, is there still a preponderance of the evidence?
There is. Number one, Your Honors, there was testimony in regards to, I'm going to back up. In regards to your question about the unsworn testimony, there was an unsworn testimony. Mr. Huddle asked questions. He was clarifying the record. And I believe there was an objection made that the court did not rule on, that was not preserved by the appellants, either at the time of trial or in a subsequent motion. Therefore, that issue is actually not preserved, but there was still substantial evidence when you look at the testimony in regards to what County Attorney Parsons said, that there was a passing in the hallway, that they were joking, those types of things.
As a practical matter, how's a board supposed to get legal advice before it takes action, potentially firing someone that is extremely likely to result in litigation? How's it supposed to do that if imminent litigation isn't covered in these situations?
Under the circumstances you just cited, anytime the board would want to fire anybody across the state of Iowa, we would have to consider it imminent litigation. But when you look at the rest of the statute, it also says where disclosure would be prejudicial to that government body. And I don't think in this case there was ever any prejudicial that was actually shown by the board. Thank you.
Aye.
I want to start with a statement that counsel just made when she was talking about malfeasance, that what Mr. Willson did would have to prevent him from doing his job. She thought that was what constituted malfeasance at the beginning of her argument. This did prevent Mr. Willson from doing his job, and more importantly, it prevented his fellow conservation board members from doing their jobs. We have testimony of that in the record. Jolyn Shantz was clear on that she no longer wanted to be on this board. Regarding the remainder of the term issue that was brought up, and that this is an equitable remedy, and that it would potentially be consistent with when people leave boards or retire or pass away, things of that nature. There's language in the statute when someone moves out of county or does something of that nature about how they'll be replaced. There's not authority for the court or for the county to make up its own board or its own terms of office whenever it sees fit as an equitable remedy.
Counsel, on the open meetings issue, I'm just curious that the focus is on the word imminent in paragraph C, but that provision goes on to say where its disclosure would be likely to prejudice or disadvantage the position of the governmental body in that litigation. I don't see any findings of fact or determination from the court on that issue. What do we do with that last part of the provision?
Well, I think there are facts in the record that ultimately give rise to a prejudicial conclusion, right? We know that people were upset about defamation and slander because they stated that. We know the county attorney had concerns about the First Amendment coming from Mr. Willson. Getting legal advice from counsel in open session on those issues would be prejudicial to the government body. It prevents them from getting that legal advice and having that discussion.
Somebody who represents governmental entities, I mean, can you talk at all about the ramifications of if we were to conclude that this was not an imminent litigation? How would that affect kind of the day-to-day representation of boards and commissions?
Yes, I can speak to that. So if we were to conclude that, I mean, there are safeguards in place when you go in under C. You have to have counsel present. Almost certainly to get the affirmative defense, counsel's going to make a finding, as Mr. Parsons did here, that litigation is imminent and we're going in appropriately. So there's an ethical ramification there if they're not finding that. So this isn't just willy-nilly, we get to go into closed session whenever we want. But if I don't have the ability to go into closed session with my clients to talk with them about their decisions that they're about to make before they make them, that's going to put me in a very difficult place as counsel to them to provide them effective counsel. It's also going to have the very real and practical effect of increased litigation and ultimately increased insurance premiums that then get passed on to the taxpayers.
Thank you.
Counsel, just help me clarify a point, and maybe we don't need to determine it, but what litigation was imminent before the board went into closed session?
Well, I think there was imminent litigation all around at that point, right? If they remove Mr. Willson, we end up here where we actually did, when litigation actually did occur following the removal. There was the possibility of a First Amendment argument. I referenced possibility of due process, which imminently could come up with the removal. In addition to that, if they didn't remove Mr. Willson, you have potential suits from the other Conservation Board members who feel defamed by him and have those issues moving forward and no longer want to be on this board because of him.
Really imminent litigation?
If you go to the Redland case, City of Redland, that Mr. Parsons cited in the record, the Court of Appeals in that case, I believe, talks about possible litigation as appropriate for imminent litigation. So I would invite you to look at that City of Redland case and review that. It's in dicta in that case. That's not the issue, but they talk about, I believe the language is possible litigation. I see I have 20 seconds left, so I want to conclude with that we do resist the request for appellate attorney fees here. And I want to ask that this court would please reverse the district court and annul the writ of certiorari and find that the Louisa County Board of Supervisors did not violate the open meetings law. Thank you.
Thanks to both of you for your very responsive arguments today. It was helpful to the court and also for the good briefing in this case. We will consider Willson versus Louisa County submitted, and we'll have a written decision as soon as we can. And we will stand in recess until this afternoon.